All right. Can we automatically pat down occupants if we pull them out of their car? My name is Anthony Bandiero, attorney and senior legal instructor, bringing you the roadside chat. All right. This question comes from an officer in Nebraska. So, is it good practice for an officer to always pat down occupants of a vehicle every time you get them out? Just to clarify, not search them, but to pat them down. All right. So the general answer is no. We cannot do this. This would violate the person's Fourth Amendment rights. Now, first of all, let's get into some case law. Number one is, I do want you to know that pat downs are searches, just like inventories are searches. And I just throw this out as a thing because I see sometimes officers get wound up on, oh, don't call them searches, don't call inventory searches. And I understand what the cop means. What they're trying to say, they're not searches for evidence, but clearly they are searches. Otherwise, it would not be controlled by the Fourth Amendment, because the Fourth Amendment only cares about two things: searches and seizures, right? But they're prescribed. They are narrow and limited searches. The inventory is a search for valuable items and dangerous items and so forth. A pat down is a search for weapons, not a search for drugs and so forth. So that's the first thing I want to teach you. The next thing is that there is no automatic pat down rule, generally speaking, under the Fourth Amendment. They're based on armed and dangerous, right? So if you go to court and it comes out that you have an officer, I shouldn't say you, but an officer has an automatic pat down rule for people they pull out of the car, then the court is going to slam that. There's no way that they're going to uphold that. Basically, they're going to say, well, then you always violate people's rights because you need to articulate armed and dangerous. A good Supreme Court case on this is Arizona versus Johnson, 2009. A stop and frisk may be conducted without violating the Fourth Amendment's ban on unreasonable searches and seizures if two conditions are met. First, the investigatory stop, the temporary detention, must be lawful. A requirement met in an on-the-street encounter when a police officer reasonably suspects that the person apprehended is committing or has committed a crime. Okay, well, that's the traffic stop, is at least a reasonable suspicion, probably probable cause of some kind of violation. But second, to proceed from a stop to a frisk, a pat down for weapons, the officer must reasonably suspect that the person stopped is armed and dangerous. Okay, so you have to articulate that. It's not a very high standard. It's just something more than a hunch, right? But you don't need certainty, right? You just need a reasons to believe that the person could be a danger to you during this encounter. And, that's a whole question of itself about how you get there. But I have a book called the RS and PC Pocket Guide that goes into or trying to articulate armed and dangerous. But there's your answer. Do not articulate that there's this automatic pat down rule. If cops are taught that way, it violates the Constitution. If cops are doing that, it violates the Constitution, right? You got to articulate armed and dangerous. All right? All right. If you like what I'm doing here, before you leave, I wouldn't mind. I really appreciate it, actually, if you would just hit the like button, subscribe, share with your friends, comment, and so forth. That all helps the channel. And until next time, my friends, stay safe.